The pending matter, my lord, allotment has been given by the District Land Advisory Committee. Matter has been sent to the state government, my lord, but he has not given. He is a retired army man, my lord.
Okay, give it to the court, master.
May I please, Lordship, I beg to mention a writ petition for listing, Lordship.
What is the subject matter?
It is writ petition, petitioner was constructing a house, Lordship, and before they were preparing for a Sat Dhalai, Lordship, and the Pachala Municipal Board issued a notice to stop the construction, Lordship.
Okay, give it to the court, master.
Monday, Lordship.
No, give it to the court, master. Allot the date. He will allot the date.
All of this.
16? Yes. 25th. No, let's see, date 2024 matter. Okay. On the prayer of Miss S. Kemprai, Land Standing Council, KAAC, which prayer is made with the consent of the Land Council for the other sites. Leads the case after 1 week. After 1 week,
May I please, your Lordship?
on a date to be fixed by the office. Yes.
May I please, your Lordship? Lordship, I beg to mention item 3, your Lordship. In this matter, Lordship, pleadings are complete, your Lordship.
Huh.
3 years. Take care for final hearing.
When do you want to admit?
Yes. Yes.
We admit?
Yes, Lordship may admit.
Okay.
Both of the admissions is also.
Let us admit. Heard Mr. P.K. Bora,
Yes, your Lordship.
Land Council for the petitioner. Petitioners and Mr. B. Gogoi, Land Standing Council, Finance and Taxation Department.
Here I appear as additional department.
Okay.
Industry department is there.
Okay, Additional Advocate General, Assam, for the state respondents. First of, the Council for the parties have submitted that exchange of pleading is complete. First of, it will be issued. First of, as list the case for hearing in due course.
Lordship, another prayer, Lordship, for item number 10 and 11, Lordship. Lordship, today Dr. Saraf is indisposed, Lordship.
Okay.
14 meter in India, my lord. That's the second week of December.
Okay. Mr. P.K. Bora, Land Council, appearing for the petitioners, has submitted that he is being led by Mr. Dr. A. Saraf in these cases. And as Mr. Saraf, Dr. Saraf is indisposed, he has sought for a short accommodation. First of Mr. B. Gogoi, Land Additional Advocate General Assam for the state respondents, who is in attendance, has submitted that he has no objection to the prayers were made in view of the ground cited. So, as sought for and agreed to by the Land Council for the parties, release the cases in the date in the second week of December.
The interim order that may be continued.
The interim orders, if any, shall continue till the next date of listing.
Lordship, item number 3, there is interim order.
Interim order, same item number 3,
Oblige, your Lordship.
if any, huh?
My Lordship, bring for listing of a petition for motion, Lordship. Matter is, Lordship, PWD road was sanctioned as per state cabinet decision, but subsequently the road is being constructed to a different roadmap, Lordship.
Motion.
Yes,
Next week?
Can you Monday, Lordship?
Next week, not Monday, Wednesday.
Problem.
Yeah, please, with your Lordship, I beg to mention item numbers 13 and 14, your Lordship.
13?
And 14.
Yes, you are for the petitioner.
Yes, your Lordship.
Yes.
Lordship, this matter may be taken up after 2 weeks. Sir.
Okay, on the request of Miss
HJ.
H. Jane. H.
Yes.
Okay, H. Jane, Land Council appearing for the petitioner. The cases stand adjourned for 2 weeks. Who is the Miss
Appearing from respondent, Lordship.
as Miss
N. Kakoti,
N.
Lordship.
Kakoti, Land Council appearing for the respondents, CGST authorities has given consent. First of.
May I please?
A mention memo circulated. A mention memo to that effect has also been circulated yesterday.
May I please, Lordship, I beg to mention item number 21 of supplementary list, my lord. In this matter, my lord, service has already been completed, my lord.
We don't know who will seek. Huh?
Let the matter be fixed for.
We'll check thereafter. I don't know why it has come by order.
My lord. Obliged.
My lord, I beg to mention for listing of the case, my lord, listing of the case in admission column, my lord.
What is the subject?
Subject, my lord, in Fancy Bazaar, my lord, there is some.
Fancy Bazaar.
Yes, my lord, some.
Mr.
after-
M.J. Borua is related to Fancy Bazaar. Okay. Give it to the court master.
Yes, sir.
Daily list for motion, item 1.
Yes, let us understand your case on the maintainability.
On maintainability.
Yes.
My lord,
Let
They
us
have,
understand what is the
state of,
background. What is the background?
my lord, pursuant to an advertisement,
Let us see
Uh,
which is the advertisement.
I am not for annex in the,
Okay. You have stated.
but I have copy.
You have stated.
Yes, my lord,
Okay. Let me read the first part.
in the GEM platform, my lord. But I have given the advertisement, extra copy, my lord.
So you floated the tender in the GEM platform,
Yes, my lord.
right?
It is necessary required for the government
Okay.
and accepted.
So the territorial jurisdiction to entertain this petition as per clause 17 of the GEM. What is clause 17?
My lord,
What is clause 17?
17, clause 17 of the GEM contract.
Hmm.
Huh? At page 36, my lord. Law governing the contract. The contract shall be governed by the law of India for the time being in force. 2, my lord. Irrespective of the place of delivery, the place of performance, or the place of payment under the contract shall be deemed to have been made at the registered address of the buyer and oblique or primary buyer. Jurisdiction of court, the court of the place from where the contract has been made shall alone have jurisdiction to decide any dispute arising out of or in respect of the contract. My lord, before that 35 may be reduced, my lord. I will 35 my lord. Page 35. In 16.1, my lord.
Let us read 16.2.
2 years arbitration.
16.1 or 16.2? 16.2.
16.2, my lord.
Arbitration.
When 16.3,
Let us read totally.
and clause is that.
Let us read in the
And-
event.
My lord 3, my 2,
No,
subparagraph.
let us read totally. Don't skip, jump here and jump there.
No, my lord.
We are deciding maintainability.
Maintainability.
In the event, read. Sir, read.
16. 16, my lord.
16 or 16.2?
16.2. My lord, one subparagraph
Don't go to subparagraph.
1.
First, go to the heading, main part.
In the event of any conflict or dispute arising out of or in connection with the contract place for GEM, which has been resolved in accordance with the procedure laid down in clause 1.
What is clause 16.1?
16.1, my lord.
What is clause 16.1?
The amicable settlement.
Huh?
Amicable settlement.
Amicable settlement.
The aggrieved party may invoke arbitration by sending a written notice to the other party. The procedure for appointment of arbitration tribunal shall be as follows. In case where the total value of the contract is less than 1 crore, the same shall be referred to a sole arbitrator mutually appointed by the parties. Where the total value of the contract exceed to 1 crore, the arbitration shall be conducted by a quorum of 3 arbitrators. Each party shall be entitled to appoint an arbitrator, and the 2 party appointed arbitrators shall within 30 days from their nomination and appoint a third arbitrator. That is the presiding arbitrator. In case of failure to appoint the presiding arbitrator within a period of 30 days from the date of nomination of the 2 arbitrators by the respective parties, the aggrieved party shall approach the High Court, under whose jurisdiction the principal place of business of the buyer, department, organization is located, to appoint the presiding arbitrator as per the provision of the Arbitration and Counseling Act 1996 as amended up to date. The arbitration shall be conducted in English language. The post of arbitration shall be the next 4, my lord, or 6, my lord. The award of arbitrator shall be a final and binding on the parties of the contract. The arbitration shall be governed by the Arbitration and Conciliation Act.
Now read paragraph 5.
My lord, the seat of arbitration shall be at the place where the principal place of business of the buyer, department, organization shall located.
Now read paragraph 5 of the repetition.
Why? That the petitioner beg to state that the LGB RIMH entered a government e-marketplace, in short JAM, my lord, contact number such and such 5/11/2021 with response number 1 for manpower service valued at rupees 130,87,348.56, effective from 8/11/2021 to 7/11/2022. The contract awarded through a tender by bid number such and such dated 8/9/2020, where the response number 1 mandatorily requires to comply with labor laws, including the Minimum Wages Act 1948, Section 12, Payment of Wage Act 1936, Section 5(1) A, my lord, and Contract Labor Regulation and Abolition Act 1970, Section 21(4). Clause 4.1, 5 and 8 of the JAM contain mandated timely wage payment within the 7th day of each month, EPF, ESI deposit within 15 days. The prohibition of unauthorized collection of money from the workers. Clause 8 of the JAM contract prescribes penalties for delay. Clause 11 allowed termination for breach of terms and conditions mandated in the contract, and clause 16.2 of the JAM terms and conditions designates the place of buyer, Tezpur, Assam, and as the arbitration chief. My lord, 6 maybe. My lord, the petitioner beg to state that the response number 1 committed multiple breach of the JAM contract, including delayed wage payment in the month of November 2021, 5 days delay, December 2022 days delay, and January 22, 11 days delay, February 22, 17 days delay, April 22, 32 days delay, May 22, 26 days delay, June 22, 2022, 19 days delay, July 2022, and August failed to pay salary EPF, ESI, relating the clause 4.1 and 5, 8, 5 in sub-rule 7 of JAM contract. Section
that's a
5,
PDA.
1A of the Payment of Wages Act. B, my lord, failing to deposit EPF ESI due from July and August 2022, breaching rupees 4,39,000 16, breaching clause 4.1 of the JAM contract. And C, my lord, collecting rupees 5,16,650 unauthorized from the workers violating clause 4.1 of the JAM contract. These breach were communicated to respondent number 1 by notice dated such and such. Dated 13/1/2022, 18/1/2022, 21/22, and others. The deponent humbly seeks to leave of this honorable court to submit all invoices submitted by the respondent number 1. Records of all the transaction copies of the collecting fees from the believers unauthorizedly by the respondent number 1 and sanction order of the deponent if directed by this honorable, which substantiated the claim of the deponent regarding the violation of the clause of the JAM contract by the respondent number 1. I have annexed some document. We have to pay directly to the ESI contribution, my lord, EPF, ESI, etc. to the department directly. Afterward, deducting it, the payment, due payment from the respondent number 1. And we have to pay the salary of the service workers of the seller. My lord, to 7 may be, it is stated here.
Yes.
The petitioner begs to state that withheld payment pending corrected invoice EPF ESI proof as required by clause 9.2 and 9.3 of the JAM contract. Payment were made promptly upon compliance. Penalties were imposed. Rupees 4,000 for December 2021, rupees 3,400 for February 2000. In the respective month due to the delay in payment to the laborers in compliance of the JAM contract. Due to persistence breaches, the petitioner forfeited the PBG of rupees bank guarantee, my lord, on 16/12/2022. Impose a cancellation charge of rupees 13,08,735 as per clause 8 of the JAM contract. Terminated the contract on 26/8/2020, invoking clause 11 of the JAM contract. The petitioner paid wages for July, August 2022, rupees 4,39,016 and directly to workers via NEFT in compliance with section 21(4) of the Contract Labor Act. It is pertinent to mention that in spite of withheld penalty amount, the petitioner has paid the bills of the respondent number 1 in each month within 45 days, which is the minimum permissible limit as per the MSMED Act. This is the permissible act. Thereafter, the petitioner, the respondent number 1 requested to release the But because of multiple breach of contract, the terms and conditions, we terminated the contract. My lord, on 6/12/2022,
Hmm.
page 90, my lord.
In the FAQ, which one you are referring to?
My lord,
FAQ?
effective from one year, my lord, from
FAQ, sir.
FAQ. Frequent
Ah,
answer question.
which one? Which question?
Which question?
Which
is,
question answer
madam,
you are referring to?
Frequent at page, my lord, 100. At
Page
22,
100.
question number 22 at page 101. Where the council shall decide on breach of contract between buyers and supplier, such as the rejection of goods for quality or deficiency by buyer as a ground for refusal of dues to supplier. Breach of contract is not within the scope of MSMED Act. Rejection of goods should be genuine.
Now,
within
where is the complaint? Where is the complaint submitted by this respondent?
Respondent,
Contractor.
MSCD,
Before Felicitation Council. Page
Respondent,
103.
yes. This is the 103, my lord.
Where is?
Hundred three, my lord. Malay in the middle, the opposite party from the micro small enterprises facilitation council.
Hmm.
It is the Delhi, my lord. It is considered by the state of Delhi, my lord. What is the my lord in the middle, my lord, after opposite parties, my lord. What is the MSEFC has received an application from MS Rajesh Bagra of MS Green Alliance Engineering Services Private Limited, hereinafter referred to as supplier, against the buyer, MS Lokapya Govindan Bodolo Regional Institute of Mental Health, hereinafter referred to as
He is claiming an amount.
Huh?
He is claiming an amount,
Yes.
is it not?
Yeah.
40 lakhs, 68,348.
Yes.
Is it not?
Yeah. But a breach of contract.
But is different. Ifs and buts are different. But he said he claimed an amount.
Claim an amount.
Right?
Yes.
Rightly or wrongly, that is a defined issue.
But
That will be decided.
that should
Right.
be decided.
He made a claim
Yes.
before the Facilitation Council
Yes.
under section 16.
16.
Right. Then they advised that first you conciliate. Right. And they advised you to make the payment.
Yes.
Right. Then you did not make the payment, perhaps.
My lord, I've
Those are yes or no, that is what I am asking. Not your
right.
submissions.
But instead of
Not your submissions.
yes, but
Did you, when this letter was sent to you,
yes.
page 103,
Yes.
did you make payment? Where is this annexer 15? Which paragraph is the relevant paragraph? Mechanical advice to pay. Close the matter on 38th. Referred for arbitration. Without considering the objection of the petitioner that the claim of was a penalty amount does not fall under the scope of MSMED Act. The petitioner explicitly objected to the jurisdiction 3/4/2024.
I have submitted in response to that, my lord, I have submitted our objection before the council at page 106, my lord.
106.
That it is not maintained in MSMED Act, my lord.
Okay. Then
They I stated that it is a termination for violation of the GEM contract. but,
okay.
My lord, it is not maintainable under MSMED Act.
Oh, that is your consistent stand. Let us examine first the sequence.
But
Right from point 0 to point 100, you are saying that only.
Yes, my lord. After that, at page, my lord, 109, my lord.
What is this?
After closing the case, that
Who is this?
council,
I've been established under so and so, right? So and so.
By this, my lord, refer this case to the Delhi International Arbitration Chamber.
Why subdivisional magistrate came
Magistrate,
into
it is,
picture?
it is, it
18.3.
is formed by the state of Delhi, my lord, for dispute under MSMAD Act. To give some relief for due payment, outstanding payment, and for delayed payment to the
One.
in
Oh,
enterprises.
it was when 31/8/2000,
35, it is only
2025.
25.
It started when this they invoked section 16 when
16, my lord,
what is
first
the
he 90, my lord, page,
27/3/2024.
90 page. 16, my lord, first feet.
Act of so and so. Okay,
And he, there
that has been 18 has been amended, but that has not been given effect to, I think. Section 18 of the MSMED Act.
16, my lord, 18 says, my lord. I think, my lord. 18 says reference to micro and small enterprises facilitation council. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the micro and small enterprises facilitation council. On receipt of two, my lord, on receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institute or center providing alternative dispute resolution services by making a reference to such an institution or center for conducting conciliation and provisions of section 65 to 81 of the Arbitration and Conciliation Act 1996 shall apply to such a dispute as if the conciliation was initiated under Part 3 of this Act. My lord, they referred the case to the Delhi International Arbitration, but in violation of the SCAM contract, my lord.
Oh, stop for the timing. Repeating violation. Go through the sequence first.
Yes, ma'am.
Now you answer directly. Two acts are involved. One is MSMED Act 2006. The other is Arbitration and Conciliation Act 1996. Right? None of the respondents here is either government or an instrumentality of the state. This is a statutory body. Respond number 4. But 1, 2, 3, not. Respond number 3, a senior advocate
Yes.
appointed as arbitrator.
Arbitrator.
2, an arbitration center.
Yes,
1 is a contractor.
yes, my lord.
4 is the council. Now, I have asked you to go through the judgment of the Honorable Supreme Court authored by Justice Narasimha.
Yes,
Have you gone through?
yes, my lord, but,
Have you gone through? Yes
Yes.
or no first?
but fundamental.
Yes or no? Have you read it?
Yes, my lord.
Read. Okay. Now, second question. How your case is distinguishable?
No, they are.
Have you gone through the facts of that case? And other judgment referred there, Horsaran Dasgupta versus Union of India, Pami Digantam Sri Narasimha, rendered on May 14, 2025. And the other judgment which has been extensively relied on, this is Gujarat State Civil Supplies Corporation Limited versus Mohakali Foods Private Limited. 2023 6 SCC 401. Have you read those?
In those cases, not read, my lord. I,
Not read. I requested you.
my lord, I have proved.
Did I request you or not?
Yes, my lord.
Huh?
Due to city.
So the request is not.
No, no, my lord, no. My lord, we have, try
Taken
to
note
find-
of.
Try to find out in my favor, my lord.
In your favor, when this is squarely against you,
Because,
this judgment is squarely against you. Because I am not very conversant with MSMED Act and Arbitration and Conciliation Act. But still, when I read it, all this ZEM, right? The arbitration agreement, arbitration clause incorporated in the agreement,
Yes.
and the seat of arbitration. You say Tezpur.
Yes.
All have been dealt by the judgment, and because of the overriding effect, it says MSMED Act is a special statute, Arbitration and Conciliation Act is a general statute in comparison to MSMED. So MSMED Act will have a overriding effect. And whatever are the issues, you have to submit to the jurisdiction of the arbitrator, where you can raise all these issues, including the issue of jurisdiction. Right? There also, they raise the issue, seat of arbitration as per our agreement is Bangalore, not Delhi. Right? But MSMED Act says once the registered contractor is a MSMED unit, then if he invokes Section 16 and the Facilitation Council undertakes the proceeding under Section 18, and once it invokes 18(3), everything under the carpet. That will only prevail. So I requested you.
my lord,
The coordinate bench also expressed that maintainability. I did not know initially, but why the coordinate bench has said so, I tried to study along with you.
my lord,
And I requested, then having found 3-4 judgments of the Supreme Court,
yes, my lord.
I thought that it would be
Oh,
better
oh.
to put it across you. And
In,
still you did not read the judgment.
no, my lord, I have, my lord. I have my judgment, my lord.
Okay, show us.
My lord, one thing is that your lordship may be considered that MSME Act is applicable when due is outstanding due is there or delayed payment. They violated the terms and
They see the complaint, sir. That will be decided. We are not into that. You terminated.
jurisdiction were.
You terminated, but come to the letter.
When the-
103. Supplier has claimed from the buyer an amount of rupees 40,68,348.
My lord, we have no,
MSME. You deny that is a different issue. We are not into it.
yes. But termination. But
Termination, irrespective of termination. You raise all issue before the arbitrator. And that arbitrator, as per the MSMED Act, has full jurisdiction. And lastly, when Union of India requested Solicitor General, he submitted that his client may legitimately raise and contest before the arbitral tribunal. Then Supreme Court said, learned arbitrator to permit the parties to raise and argue all questions of law and fact as are legally permissible. And there they also raised the issue, seat of arbitration, then Arbitration and Conciliation Act, then the specific agreement,
yes.
right? That is also instrumentality of the state. In both the cases, in Mohakali as well as this Harsaran Dasgupta. Harsaran Dasgupta, it is Indian Space and Research Organization. Right? A much more acclaimed body. And in Mohakali, it is Gujarat State Civil Supplies Corporation. Public sector under it, but same.
My lord, in case, my lord, Honorable Supreme Court in my.
No, have you gone through this Gurs Harsaran Das?
In case violation has occurred, fundamental rights and
No fundamental, in a contract,
fundamental.
in a private contract, no fundamental rights, sir.
My lord,
What is private contract?
principle of natural justice. and-
What is private contract?
But it.
There are two kinds of contracts, sir. One is statutory contract, the other is non-statutory contract,
Yes, ma'am.
right? Non-statutory contracts are governed by private laws. Contracts Act. There is no fundamental right involved. Both the parties entered into a commercial transaction. Yes, there are statutory contracts, mining lease. Those are statutory contracts. This is purely manpower supply, whether clean bed sheets are provided or not. Where from your fundamental right comes?
My lord,
Don't say fundamental right at a drop of a hat.
my lord,
Two entities entered into an agreement for the benefit of both of them. Where is the fundamental right? That you provide clean bed sheets, clean pillows, right? Cleaning services at the minimum of price. And we agree to your price. Where is the fundamental right?
my lord, their
Don't raise
performances
fundamental.
are, my lord.
Have you read these two judgment or not? That is one, my question.
Yes, ma'am, one is, I have read it, my lord,
Read it.
but
Then take
my
down.
lord, I have three judgments in support of my.
Which year?
My
The judgments are of which year?
2000.
2000.
2014.
2000.
14, my lord.
14.
KK section, person international
Okay,
commission of.
that is public function. Discharging public duties.
Yes, my lord, whereas 20.
Sir, Mr. Dotto. Article 14, 12. instrumentality of the state. No doubt, you are an instrumentality of the state. There are two distinctions. There are services extended by an instrumentality of the state. The main core function is public function, public duties on the part of this petitioner. Yes, extending healthcare services to mentally ill persons. Right.
Money will go back
Ah.
and check out.
But entering into an agreement for providing clean bed sheets, clean pillows, cleaning services, keeping toilets clean, that is, hiring manpower service is not discharge of public duty. Have you read KK section up fully? Huh?
Yes, my lord.
Which paragraph? Which paragraph?
20, my lord. 20. Page 19 of 20.
20.
20, my lord. The term authority used in Article 226 in the context must receive a
No doubt. No doubt. No doubt. You are Article 12. Let us go further.
liberal meaning, like the term in Article 12. Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 226.
Which paragraph you are reading?
20, my lord.
20
Page
is
19 of 25.
20 is
Section of-
very small line. Line is keeping in view the aforesaid matrix. We proceed to the issue which was canvassed before us. That is the only line. Page 20. Paragraph 20.
No, my lord, 19 of 2025, 19 of 25, page number 25.
Huh?
19 of 25 of KK section.
Please mark it.
KK section of
The way you presented the petition, it has to be appreciated. But reading between the lines,
19 of. To 14.
mark the paragraphs, please. Mark the paragraphs.
Paragraph. 20. Is 19 of 25.
Oh, this is quoted from somewhere.
My lord,
This is Andi Mukta, not KK Saxena. Okay, first you come to page 14.
14, my lord.
Paragraph 22.
My lord, it is not a statutory body, but
Come to page 14.
paragraph 14.
Come to page 14.
Yes, my lord.
Paragraph 22. Read.
After taking note of certain judgments of the judgments of this court, wherein the principles are laid down as to how the term authority used in Article 226 is to be read in contradiction to the same term used in Article 12 of the Constitution.
Next line.
What-
Next line. What would
What
constitute?
constitute public function and public duty? The court took note of.
So this is
so-
what would constitute public function or public duty.
read
Now come to your Andi Mukta.
My lord.
That paragraph is part of paragraph 35. Okay, come to your paragraph, page 19.
19. Page 19, my lord. The term authority used in Article 226, the context must receive a liberal meaning like the term in Article 12. Article 12.
This line is important.
Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 2 to 6 confers power on the High Court to issue writ for enforcement of fundamental rights as well as non-fundamental rights. The word any person authority used in Article 2 to 6 are therefore not to be confined only to statutory authority or instrumentalities of the state. They may provide any other person or body performing public duty. The form of the body concerned is not very much relevant. What is irrelevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owed by the person or authority to the affected party. No matter what means the duty is imposed. If a positive obligation exists, mandamus cannot be denied.
Now read the following lines.
In para 15 of the Andi Mukta Toguru cases,
The court spelled out.
spell out two exceptions to the writ mandamus. writ of mandamus. One, if the right is purely of a private character,
Your case falls in it.
mandamus can issue.
No mandamus. Don't skip no.
No
Don't read according to your convenience.
If
No mandamus can issue. Private character. This agreement is clearly a private character. What more judgment?
my sir, I have the
That is against you.
that and this case, my lord, I have
Andi Mukta. Same. No mandamus.
and the case is there, my sir.
Huh?
17 para 17. Para 17.
Same paragraph. Paragraph 20.
17 and 20, my lord.
17. 17 quoted here.
And 20, the term authority used.
Same. You have read already. You have to read also paragraph 15 of Andi Mukta. Please read. Paragraph 15 of Andi Mukta.
If the right are purely of a private character, no mandamus can issue. If the management of the college is purely a private body with no public duty, mandamus will not lie.
You come within first one.
My lord, we have discharging our duty for the public interest. And the money goes from the public exchequer.
Yes. Any more judgment?
My lord,
Any more judgment?
17, my lord. 17 also here, my lord, and 20, my lord.
Okay. Hand over.
Then other is with
Hand over Andi Mukta.
Andi Mukta. Huh?
A Korean color field to do.
And I also relied upon the section.
Aim. Manu Mohakali also.
No, I got that. And the other relies on the whose jurisdiction, my lord. Willful, my lord.
Korean color field.
Willful, are we at us for news for some?
Okay. So, how does Whirlpool come here?
Well, initial justice, because
Huh?
we are, because we have the condition, but they, in spite of,
Whirlpool, why?
my lord, para 15 my lord,
There are 15.
15 my lord. Page 7 or my 7 my lord. Page 7. Page 7 and a bottom my lord.
Which
Under-
one is applicable? Enforcement of any fundamental right?
Yes, my lord.
Fundamental right. This agreement is a statutory contract or
It is a government
non-statutory
policy, my
contract?
lord. Government policy,
Huh?
government policy, my lord.
What government policy?
But it is established by the government, my lord.
So, even in a contract executed under Article 299 of the Constitution of India is not a sovereign contract or a statutory contract. Principle of natural justice, Hollywood jurisdiction.
Natural justice.
Okay, then
And
Tatia,
Tantia is for
which paragraph?
my lord, 33 and 34, my lord. When alternative remedy is there, my lord, court can invoke. We have alternative remedy under
Apart
Article
from even question of mineral.
33 and 34. my lord. The last page.
Yes, these are.
My lord, this is my submission. That they first after termination, they invoked the power under the 16.1 to amicable settlement. And
Whether after termination, an MSME unit can invoke MSMED Act or not?
but when
After time, even after termination, you have rightly terminated. Whether the MSME unit can invoke section 16 of the MSMED Act or not,
not my
where from you are saying?
my lord, when payment is due, he is claiming.
No, he has claimed. I'm not saying that it is due. He has claimed.
But each the council or
We are not adjudicating whether he is rightfully entitled for such claim or not. That is a different issue. That is to be either by the going through the evidence thereafter. The question is whether he can invoke section 16 or not, even after termination of a contract of agreement. That is the only question. I think MSMED Act is silent.
date from which or rate at which interest is payable. Where any buyer failed to make payment of the amount to the supplier.
Everything is in a realm of allegation only, right? In the realm of claim. They have claimed. Right or wrong, that will be decided by appropriate forum. We are not into it. Have you understood my point?
Yes. Appropriate form.
That will be decided whether they are entitled or not entitled. But here you have raised some very difficult questions. And with those difficult questions, the question of maintainability of the writ petition is linked. So that is why we are hearing you on the preliminary point. Otherwise, if you go cross the barrier, there will be two parallel proceedings. One here, other there.
The jam terms and conditions says the
Do-
both
you
parties
put in-
are binding.
Kali? 20.
The jam contract already says that it is valid agreement. And the circumstances one, it
Okay,
is specified in the terms and conditions of.
okay, I have heard you.
My
Let
lord,
me go through these decisions. And this Gujarat State Civil Supplies and Horsaran Das Gupta and few others, all are latest decisions. 2023, 2024, 2025. Then we'll decide. We'll keep it as part of. If you cross the maintainability, then thereafter we'll issue notice. Heard Mr. A.K. Dattol, Learned Counsel for the petitioner on the point of maintainability. Full stop. As the hearing is, as Mr. Dattol's submissions are not complete, comma, lays the case again on 18/11/2025. As part heard, we'll take up at 3 o'clock. We'll pass the order. For you. May act only, huh? This agreement can be kept.
Yes, my lord. And my lord, another is that is not next the 16.1. I have spoken.
Okay, give it 16.1.
Yeah, condition.
Huh.
16.1.
Okay, next.
Supplementary list, item 17.
Yes, Mr. Sharma, I have not understood your case.
Lordships.
Mr. Sharma, two questions first. In the prayer portion, you said you are challenging the judgment and order dated 21/10/2024, passed in Revenue Appeal 73 of 2009,
Lords.
right? In that Revenue Appeal, the respondent number 4
Lordships.
was the appellant,
Lordships.
right?
Lordships.
And you were your husband was the respondent,
Lordships.
and the appeal was dismissed,
Lordships.
meaning thereby the judgment was in favor of your husband. And thereafter your husband died. If the appeal of the your opponent was dismissed, how you're aggrieved that the judgment is in your favor?
Lordship, page 19, Lordships. That paragraph 11, that last sentence, Lordships. Page 19, paragraph 11, last sentence, the Deputy Commissioner was correct in reversing the CO's cancellation of the mutation.
Hmm.
This is against me,
Yes.
Lordships.
CO cancelled your mutation.
Lordships,
Is it not?
Lordships,
CO cancelled your mutation. Deputy Commissioner reversed it,
Lordships.
meaning thereby it has come back again in your name.
Lordship, this sentence, it is against me, Lordship.
No, Deputy Commissioner was correct.
Lordship. Lordship, first, I got
In
the-
reversing the CO's cancellation of the mutation. Now come back. Previous page. Para 3. The learned circle officer set aside the mutation in favor of respondent number 4 by order dated 11/10/2007 in miscase number so and so. Right?
Lordship,
That you have annexed.
Lordships,
You have annexed, I think.
Lordship.
Maybe. Then, next line. However, the Deputy Commissioner cum District Magistrate Kokrajhar reversed this decision in mutation appeal number 1/2008, upholding the earlier mutation granted on 11/4/2005 in favor of respondent number 4. Respondent number 4 is you,
Myself,
right?
Lordship.
So, this fact and aggrieved by that order, appellant has approached this court.
Lord.
Appeal was dismissed. And Deputy Commissioner's reversal order has been upheld. Now, how you're aggrieved?
Lordships, I got the mutation by order dated 11/4/2005, Lordships. Now.
No, you did not get. It was cancelled.
No,
Please read.
11/4/2005, Lordship.
No, see, don't pick up that. Read the sentence. The circle officer Gokhaigaon set aside the mutation in favor of respondent number 4 by order dated 11/10/2007. Right.
Lordship,
However, the Deputy Commissioner reversed this decision in mutation appeal number so and so, upholding the earlier mutation granted on 11/4/2005 in favor of respondent number 4. 11/4/2005 was in your favor. Then it was cancelled on 11/10/2007. But the Deputy Commissioner again changed it to your name. Right. And agreed by that, the appellant preferred the petition. I had gone through why this petition has been preferred. When a judgment is in your favor, shall we set aside this? That can be done. If you make submission that this is to be set aside, I'll set aside.
Lordship, I will withdraw the case, Lordship.
Huh?
I may be allowed to withdraw the writ petition, Lordship.
You wasted my time. I tried and tried. By civil suit, but there are two plots. By civil suit, one has gone against you.
Lost.
You have not preferred any appeal. That has attained finality. Now, this is in your favor. And you are challenging it. If you make submission, I will set aside. Yes, Ms. Burman, I can set aside. By consent. Then everything goes. Why you are digging your own grave?
I may be allowed to withdraw.
Yes, Miss But I read and read. Mr. Sharma, don't file this kind of petition. It is wastage of court's time. Heard Mr. R. Sharma, learned counsel for the petitioner, and Miss M. Borman, learned junior government advocate Assam, for the respond number 1 to 3. So after hearing Mr. Mr. Sharma, learned counsel for the petition, after making submission at some length, has submitted that the writ petition has been misconceivedly prepared. He has therefore paid for withdrawal of the writ petition. So, in view of the above submission made by Mr. Sharma, learned counsel for the petition, the writ petition is dismissed on withdrawal.
Item 18.
What is the issue?
My lord, that rice, my lord. Harvesting, praying for my lord. Crops at
Okay.
my lord.
Okay.
My lord, admittedly, we had already been evicted, my lord. The area wherein we were residing by our homestead lands. Now, my lord, during the course of our stay therein, my lord, this is the last crops we did cultivate, and now it is ripen up, my lord, for the purpose of harvesting. Now, the state and the forest department is saying, my lord, that as there is no non-forest activities is not permissible under the law. So therefore, my lord, harvesting.
If the foundation is second, everything is second.
My lord, yes,
If the foundation is,
correct, my lord.
then entire superstructure falls.
But my lord, what is my lord, the issue is that we have heard, my lord, the petitioners have informed me that the crops which we did cultivate, my lord, is now going to be handed over to some organization, something like that, my lord, that they are being invited to take away the crops, my lord. That is also will be in violation. will
Yes,
be
Mr.
Non-forest activity.
Goswami, what is the best way out?
My lord, best way is to, my lord, let the crops remain inside the forest, let them die their own course, my lord, because law doesn't permit and there is no move to, my lord, invite some organization and allow them to cut, my lord. If we cannot allow petitioners to go inside the forest and harvest, we will not allow anybody to go inside the forest and harvest, my lord. My lord, may kindly peruse Assam forest regulations for a moment. It is absolutely impermissible. My lord will kindly see the courage that they have. Admittedly, they are encroachers. They have been evicted. Encroachers, my lord, now wants to again trespass into a forest and want to cultivate, my lord. Sorry,
No, that
harvest.
is out of the question.
Yes, my lord will kindly.
Allowing them to enter into the same place,
Exactly, my lord.
that is out of the question.
And in that particular area, my lord, Uriam Ghat, it's not that only rice they have planted, my lord. There are thousands and lakhs of, my lord, betel nut trees, my lord.
We are not for the.
So, to just for asking
My lord, my lord.
Mr. Goswami,
My lord.
it has to be transformed from non-forest activity to forest activity.
My lord.
So there are existence of non-forest activity there.
My lord.
To come to forest activity, you have to do away with the non-forest
Yes.
activity. How would you do that?
Usually, my lord, we go for large scale plantation, my lord.
Huh?
Large scale plantation, my lord. Afforestation, my lord. That is what we do.
Huh.
So if my lord,
Otherwise, this is of value.
this is of value, my lord, but what I'm on, my lord,
What I am saying that
value could have been
put it in the
expected.
Treasury,
My lord,
you can put it in the government treasury.
that can be done, my lord, but not by the petitioners.
No,
by,
no, by the deputy commissioner himself.
That can be done. In fact, my
With
lord,
the DFO, thereafter we are not sketching our head at this point of time. You keep it in your treasury.
difficult will be, my lord, asking the DFO right now to go for harvesting. My lord. They are also not skilled, my lord. They are also busy in other activities, my lord. So it will take some time to take a call, my lord. It will be taken. This call will be taken by the highest authority. In fact, yesterday I had a discussion with Honorable Chief Minister.
Take
my
a
lord.
call.
He has specifically said this activity cannot be allowed, my lord.
No.
And not only the view of the government, my lord, the law also says so, my lord.
Okay, let us see.
My lord will kindly see the Assam Forest Regulations first. Section 4, my lord, defines forest produce. 4B2. 4 starts with, my lord, forest produce includes B, the following when found in or brought from a forest, that is to say, serial number 2, small Roman, plants not being trees, including grass, creepers, reeds, moss, and all parts or produce of such plants, my lord. Even if it's not tree, my lord, anything inside a forest is a forest produce. Then, my lord, will kindly see section 21. My lord, these attempts were made earlier also, in respect of, my lord, Burhasapuri Wildlife Sanctuary. It was specifically rejected, my lord. Section 21 says, my lord, acquisition of right over reserve forest, no right of any description shall be acquired in or over a reserve forest except by succession or under grant or contract in writing made by or with the previous sanction of the state government or some person on whom such right or title, right or the power to create such right was vested when the notification under section 17 was published. Now, my lord, will kindly come to section 24. Penalties for trespass and damage in reserve forest. Any person who is a reserve who in a reserve forest trespasses or pastures cattle or permits cattle to trespass or causes any damage by negligence in felling any tree or cutting or dredging any timber shall be punished. So trespassing is a punish. Anybody entering without the permission is a punishable offense. 25, my lord, F. A person who acts prohibited in such forest, 25, my lord. A person who, if we go to F, clears or breaks up any land for cultivation or any other purpose. Admittedly, my lord, in this petition, they have admitted that they have committed this offense. We have not yet registered those offenses, my lord. But a person saying that I have committed this forest offense, now I may be allowed to take out the, my lord, fruit of the offense, my lord. Then, my lord, may kindly take up Forest Conservation Act, my lord. Forest Conservation Act, 1980. Section 2, my lord. Notwithstanding anything contained in any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, may order directing, number 2, my lord, that any forest land or portion thereof may be used for any non-forest purpose. My lord, if we see the explanation, Forest Conservation Act, 1980, my lord. Rules. Forest Conservation Act, it's next the Forest Conservation. Indian Forest Act, very nice. Look, if Ekon আছে নেকি আপোনালোকৰ Indian Forest Act খন এইখন কিতাপ আছে নেকি মোক এবাৰ দিয়ক Forest Conservation Rules আছে এটোতো নতুন খন আছে 1988 Forest Act. Nice. But this act has been amended, my lord. That amended portion, this section remains same, my lord. This is now one Sanrakshan evam
Oh, I have seen that.
Samvardhan
Oh, I
Abhinayam
have seen that,
1980.
but for doing.
So section 2, my lord, restrictions on de-reservation of forest and use of forest land for non-forest purpose. Notwithstanding, my lord, got it.
Yes.
Section 2, my lord. Notwithstanding anything contained in any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, any order directing, serial number 2, that any forest land or any portion thereof may be used for any non-forest purpose. If we, my lord, now go to the explanation, my lord. Explanation to section 2, my lord. It says, for the purpose of this section, non-forest purpose means the breaking up or clearing of any forest land or portion thereof for cultivation of tea, coffee, spice, rubber plants, palms, oil-bearing plants, horticultural crops or medicinal crops. Next, my lord, any purpose other than afforestation. That is absolutely impermissible, my lord. Cultivation itself was an offense. Cultivation itself is barred under Forest Conservation Act. Now the question of, my lord, harvesting, that will be, my lord, in my respectful submission would be, my lord, compassion beyond the law, my lord. Now, if we, my lord, see section 3A. Section 3A, it says, whoever contravenes or abates the contravention of any of the provisions of section 2 shall be punishable with simple imprisonment for a period which may extend to 15 days. My lord, actually, my lord, on oath, they have said they have cultivated inside a forest, my lord. It's sufficient for the state to take cognizance, my lord. Then, my lord, there are certain orders passed by the Honorable Supreme Court as well as by this Honorable Court, my lord.
Yes.
In T.N. Godabaran, my lord, we all know, my lord, it's a perfect case of continuing mandamus, my lord. In T.N. Godabaran, it was in it,
Some order was placed earlier. This one.
my lord. Paragraph 3, my lord.
Paragraph 3.
These orders are still in force. It says, issue notice to all the respondents. In the meantime, we restrain respondents 2 to 32 from ordering the removal of dead, deceased, dying, or wind-blown trees, wood and grasses, etc. from any national park or game sanctuary or forest. If any order to this effect has already been passed by any of the respondent states, the operation of the same shall then immediately stay. So consequent to this, my lord, an order was passed by the Central Empowered Committee. That its committee itself is a, my lord, creation of the Honorable Supreme Court. Now it has got the statutory strength, my lord. That committee, I can't see the decision. Issued this letter to all the chief secretaries of all states, my lord. To the chief secretaries of all state union territories, principal conservator of forest of all state, chief warden, referring to this order, my lord, that I placed just now. You are aware that the Honorable Supreme Court by order dated 14/2000 in IA number 548 has prohibited removal of dead, dying, deceased trees, etc. from national park and on sanctuary protected area. Even the removal of grass, etc. from national parks and sanctuary has been prohibited. In view of the above order, any non-forest activity, felling of trees, bamboo, removal of biomass, miscellaneous construction activities, etc. in the protected area are not permissible without prior permission of the Honorable Supreme Court. A number of instances has come to the notice of the Central Empowered Committee where felling of tree, bamboo, digging of canals, mining, underground mining, collection of sand boulders, laying of transmission lines, optical fiber cable, pipelines, cutting of grass, collection of minor forest produce, grazing, construction, widening of roads, etc. have been allowed to be undertaken in the protected area without obtaining permission from the Honorable Supreme Court on the plea that the activities are part of the management plans. You are requested to ensure strict compliance of the Honorable Supreme Court's order.
So, Mr. Bhuya, are these petitioners before the Honorable Supreme Court also?
My lord.
are these petitioners are before Honorable Supreme Court also?
Not these petitioners, but same evictees, my lord.
Some of the.
And
evictees-
there is a status quo order, my lord. That status quo now runs against them.
No, status quo, my lord, my lord, they like.
So
to-
far, this activity itself is prohibited.
My lord,
So fruits of it.
my lord, what my respectful and fair submission before my lord is that, my lord, when there is a law governing, my lord, and if that law is governing the field, we have to abide by the law, my lord. That is the position. But my lord, my lord may kindly appreciate that these activities of, my lord, cultivating and harvesting is going on since 1970s, my lord. And now they have woken up and shaken up so suddenly, my lord. Everything has been demolished in one go, my lord. Now we are being homeless, foodless, shelterless, and now we are going to be cropless also, my lord. That is their policy. Without even, my lord, the 5 kg rice, my lord, which were allotted to these people, my lord, under the National Food Safety Security Act, that has also not been had been stopped, my lord. My lord, school-going children are now schoolless. My lord, these baby food items are also not available. Even these evictees, my lord, are not being given shelter on rented house also, my lord. They are being termed as, my lord, foreign nationals, as Bangladeshis, my lord.
No, these are political
That is-
statements.
no,
my
no,
lord.
these
This
are
is not,
not
this is not the
political
forum.
statement. I
He
can,
should go
my
to
lord,
media for
I
that. my lord.
can
He should
bring.
go to
my lord,
media. This is
all
not
these
the forum,
things,
my lord.
all
Ah,
these
in
things
fact,
in
that is not the
affidavit, my
forum.
lord. Now, my lord, one thing my respected.
We go by the law only.
My lord, my respected friend has said, my lord, that this T.N. Gudabaram case, my lord. Now, my lord, today morning, my lord, I have received certain documents, some agreements has been executed by some Naga people, my lord, with these petitioners, my lord, on the same land, same portion of land, my lord, wherein the cultivation is going on. They have allowed us for cultivating the land by the Naga people, my lord.
So my learned friend is now allowing Assam land to be transferred to Nagaland. my lord.
No, that is not my issue. My learned Advocate General, my lord, Additional Advocate General is well aware, my lord, that there is a original suit, one of 1988, is pending before the Honorable Apex Court, my lord. And in that suit, my lord, the Honorable Apex Court has directed that the status quo should be maintained in a disputed area belt. Now, my lord, this is an area which is also a disputed area belt area, my lord. My lord, I
But
would
the
not.
fact of the matter is that you don't have any valid title document.
No, that, my lord, that what we do
And
not have, my lord,
if it is forest area
my lord,
and it is non-forest activity,
my lord.
then that is difficult for
My lord, that issue,
when the
my lord,
fundamental
with all respect, my lord,
foundation is wrong.
no, my lord, that issue, my lord, is now pending before the Honorable Apex Court, my
I-
lord, that
Two
whether,
small submissions. to
Issue
My
the-
lord.
notice at this stage,
notice,
simply.
my lord,
Keep it. We are not deciding it.
my lord.
We'll issue notice at this stage.
My lord, the crops they can go for tender or something, at least it should be, my lord, the value of the property can they, my lord, preserved it for
If
future.
they wish, they can, that is
My lord,
open.
there is
That
one.
is open for take appropriate decision.
Yes, yes.
But my lord, it should not be allowed to be, my lord, harvested by some private entity.
They have no right over that cultivation, my lord. That was an illegality that committed.
My lord,
They want to, my lord, continue with that illegality. My lord, can you see that order?
That is not the illegal.
Exactly identical case, my
No,
lord.
no. We are not observing anything which is not happening as on date.
My
That
lord,
they
but-
should not be allowed.
No.
These are all statutes already provides. Why
that
should we repeat those?
No, that is correct.
Heard
My lord,
Mr.
my
Yas-
learned
yeah.
friend has said that, my lord, it is not our property, my lord, it is our hard-earned, my lord, effort has been invested in this land, my lord.
Learned counsel for the petitioners, Mr. P.N. Goswami, learned additional advocate general, Ms. P.R. Mohanto, revenue, one. Mr. P.N. Goswami, learned additional advocate general, some is stated by Mr.
I could.
I. Kolita, learned counsel for the respond number 224 post. The petitioners here in 41 in number, comma, have stated that in a recent eviction exercise, comma, the authorities in the Forest Department Assam had evicted the petitioners from a parcel of land in and around Uriamghat area, Golaghat district, wherein they claim to have been residing since several decades. Full stop. The petitioners have further stated that during their occupation of the parcel of land, they have made cultivation therein. Full stop. And the cultivation they made are now ready for harvesting. Full stop. But after the eviction, the petitions have been restrained by the Forest Department authorities to enter into the their areas of cultivation. To cut the standing straw crops, which are meant for their livelihood. Full stop. This petition, red petition is preferred. Seeking inter alia direction to the respondent authorities to permit the petitioners to enter their respective fields. As mentioned in a table in paragraph 17. For the limited purpose of harvesting and collecting the paddy and other crops cultivated by the petitioners prior to their eviction. Mr. Goswami learned additional advocacy paying for the state respondents, including the Forest Department authorities have submitted that the areas where the petitioners have claimed to have made cultivation are clearly within the boundaries of a reserve forest, and any non-forest activity is impermissible. Full stop. As the petitioners have been evicted due to their occupation of forest lands, consequently, any the activities carried out by them, which are clearly non-forest activity, are also against the law. Full stop. The matter would require consideration. The issue notice returnable on so-and-so. As so-and-so is appeared accepted. Extra copies. As it is projected, that there are standing crops inside the forest areas which are ready for harvesting, it is expected that and the same are clearly non-forest activity, it is expected that the state respondent authorities, more particularly, the authorities in the Forest Department, shall take appropriate steps for for. Changing the forest areas which are wherein non-forest activities were undertaken to areas for forest activities by taking a prudent decision on the standing crops which are stated to be ready for harvesting. First of, it is, it is however made clear that there shall not be any involvement of any third party. You take a decision.
My lord,
Let us-
obliging.
Let us
My lord.
to transform it into
Forest. area.
forest activity
Correct.
from non-forest activity. You take your prudent
My lord,
decision.
I have seen, my lord, even tree plants, my lord, if not plucked, my lord, it grows, my lord, 50 feet, 60 feet, my lord. We can consider them to be a non-forest activity. If we allow them untouched, my lord, it will go up 50 feet, 60. It's a big tree, my lord. Just
Take
an
your
example,
call,
my lord.
Take your call and take your prudent decision. We'll see.
My
My
lord.
lord, my lord.
If,
Highly obliged.
and I think it is best to auction it so that it can clear the area. Forest officials are permitted.
They are permitted, my lord.
They are permitted, so they can do it and they can sell it. If they are not entitled, at least it will be to the state.
Exactly, that resources will
Exchequer.
not.
Not
It
even-
will be to the state exchequer.
Milord, even the humans are not required nowadays. Milord, machines can do the harvesting,
No,
milord.
let them do it,
My lord.
clear the area. And
Right.
thereafter, they can put it in the treasury, thereafter we'll decide.
My lord.
Obliging.
12th
Obliged.
December, 12.
Affidavit
My
of
lord,
the deputy commissioner
my lord.
or commissioner, that has been cleared or what?
Uh,
That affidavit of the commissioner of the municipal board?
We have filed our affidavit.
You have cleared it or what?
That, my lord, the encroachment at that relevant time, that was on the way, that has been cleared.
The road is cleared,
Road is clear.
that's 16 feet or whatever.
No, that, but then, my lord, what they have done, the eastern side, 10 feet road, that approach road is there. You also will find the roof of the building, there are some rot that came out encroaching that part of the thing. That is still remaining.
That's still remaining.
Yes.
my lord,
That
I
is to be
prepared
clear.
a small note, my lord, kindly.
With Chakraborty,
My lord.
there is an inherent issue. You said in your petition that you purchased the land
Yes, my lord. At the time when
in
we were-
2005. Original allottees were your father-in-law and your mother-in-law. Father-in-law died in 2001. Mother-in-law died in 2003. How can you purchase the land from your dead father-in-law by a sale deed of 2005?
That I have made this in this note, my lord, I have given a details. In 2002 itself, all the legal heir of the original settlement holder, the father-in-law, they gave power of attorney in favor of the husband of the petitioner, who is the elder son. So he sold it off to.
You cannot, if the man died, the original person who died, the power of attorney goes.
Power of attorney
Power of attorney
is given by.
survives till the person who gives the power of attorney
No,
survives. After his death, it is non-est-in-law.
legally.
We are not into, but we will highlight.
My lord, this is regarding title,
This is an aspect
my lord.
which is very doubtful.
Actually.
Yes, by inheritance, your son, the son can get,
Yes, my lord, for purpose of
but
getting, for the purpose of getting house loan, she is
he
working.
cannot
in
execute sale deed.
That was the reason. I just spoke to them. They said just to facilitate the.
Many inherent legal lacuna in your case. And where is the 1992 modification proposal? Hmm.
My lord, it is at page 43, section 10,
Page
43.
43. And this one was done before deposit of the entire premium.
Yeah, it says so.
So thereafter premium was deposited.
Deposited in.
So it was agreed. It was agreed.
Now, my lord, they said, because possession was handed over thereafter.
Whatever.
So.
But premium was not paid. It is not a case that after premium was paid, this modification was done.
That time premium was.
Premium, this modification was done prior to deposit of the entire premium. So meaning thereby, the man to whom this order was issued, he accepted it. Meaning thereby 10 feet public road to the east.
But my lord, since then, till 2012.
Whatever.
And then building permission is also granted after examining the.
Building permission, we are not concerned with it. We are concerned with the land and the 10 feet road to the east. 10 feet, 10 feet. That has to be cleared for public in whatever way it is possible.
My lord, may I pray? Now, I was just giving it thought. So now, if the lordship is going to dispose it of, anything falling from your lordship, we are subsequently file a suit for regarding declaration of title. It may have some effects.
What declaration of title?
I mean, whatever now, if the disposal of this.
We are concerned with 10 feet road to be cleared.
My lord, if.
From soil up with a clear sky above. Not
Eastern-
all these hanging.
Eastern portion 10 feet and the western 16 feet.
That is also of concern or what?
16 feet, I think it is cleared, but 10 feet is the main crux. Because the roof is coming up to 10 feet.
Okay. The petitioner, the present writ petition, right, the instant writ petition is under Article 226 of the Constitution of India. is preferred. Assailing. An order dated 7/3/1992. Issued by the Deputy Secretary to the Government of Assam, Revenue within bracket Settlement Department, Settlement Branch. Whereby an earlier settlement proposal made in favor of one Sunil Ranjan De and Manjusri De made wide the department's office letter number is 43, RSS.73/91/15, dated 29/10/1991. Read with office letter number RSS.93/91/19, dated 7/3/1992, were modified. Full stop. In order to understand the nature of challenge made, it appears apt to refer to narrate the events preceding to the order dated 7/3/1992. Is 7/3 or 30?
First one is 7/3.
First
Then
notification is 7.
The next at 43, your page 43, your lordship will find 30th December 1992. And 7/3
Which one
order.
you are challenging?
1990, 30/12/1992.
Huh? You're not challenging that.
Now, this one, this modification is nothing but only 60% of the modifying from 100% only to the premium to the.
That is not,
That is not under challenge.
no, which one is challenge?
That is at page 43,
That is not mentioned in the prayer portion.
30/12/92.
Where is that?
Is mentioned in.
That is not even challenged.
No, that is not there, my lord. They
Huh?
challenged 7/3.
We proceeded on the basis that this was challenged.
7/3 they have challenged.
7/3 is different.
7/3 is different, my lord.
60% premium.
Yes. But the thing with.
That was favorable to the Sunil Ranjan De.
Right.
প্রথম লাইনটো কাটক আৰু in order to appreciate the nature of challenge made in this petition, it is apt to refer to the sequence of events at first. Full stop. Para. The petitioner is the wife of one C. Sanjay Kumar De. Full stop. The petitioner is the daughter-in-law of one Sunil Ranjan De, within bracket, since deceased, and Manjushri De, one Manjushri De, since deceased. Full stop. Para. Late Sunil Ranjan De was an employee of the Indian Air Force. Full stop. During his lifetime, he made an application for allotment stroke settlement of a plot of land for homestead purpose on 22/7/1979. Full stop. The sub-deputy collector, the jurisdictional sub-deputy collector, submitted a report on 25/7/1979 recommending the proposal for allotment stroke settlement of a plot of land in favor of Sunil Ranjan De. Full stop. The Jurisdictional Land Advisory Committee, in one of its meetings, held on 21/8/1979, passed a resolution for allotment of a plot of land measuring 3 bighas. 3 bigha?
3 katha.
3 katha.
15
15 shotaks at Moja Ukil Bazar. Pargana or Fargana? P-A-R. P-A-R, Pargana. Barakpar district, Kachar, in favor of Sunil Ranjan De for homestead purpose on realization of requisite premium on the condition that the land would be utilized for the specific purpose for which it had been allotted. Full stop. It was on 29/10 to 1991. The Deputy Secretary to the Government of Assam, Revenue within bracket settlement settlement bracket close department settlement branch within bracket the response number 2. Wrote to the Deputy Commissioner, Kachar District, within bracket the response number 3. Wide office letter number so and so, page 17. Whereby it was conveyed that and a plot of land measuring 3 kathas, 15 chataks, covered by tag number 256, comma, at Moja Ukil Bazar, Porgona, Barakpur. Should be settled. Would be settled with Sunil Ranjan De and his wife, Manju Sidre, after realization of due premium. Full stop. The government fixed the valuation of the land at rupees 2,20,000 per bigha, and it was conveyed that the premium would be realized at 100% of the valuation of the land. Full stop. The response number 2 was directed to take the necessary steps and to get the record stroke map corrected, and also to hand over the possession of the subject land to Sunil Ranjan De. Full stop. Subsequently on 1992, the respondent number 2, provide office letter number page 25, wrote to the respondent number 3, conveying the decision of the government that the premium would be realized at 60% of rupees of the 60% of the 60% of the total valuation of the land at rupees 2,20,000, and a premium should be realized in 2 equal installments immediately. On receipt of the approval, the office of the respondent number 2 directed the respondent number 5 on 27/3/1992 to hand over the possession of the subject land to Sunil Ranjan De and Manjushri De, as Sunil Ranjan De had, in the meantime, deposited the first installment of the premium on 25/3/1992. Full stop. The office subsequently, the office of the respondent number 3, by its office letter dated 22/04/1992, directed the respondent number 5 to take necessary steps for issuance of a patta in respect of the subject land in the name of Sunil Ranjan De and Manjushri De. Full stop. Prior to that comma, the possession of the subject land, formal possession of the subject land was handed over to Sunil Ranjan De and Manjushri De on three four 1992. Full stop. Para. On 30/12/1992, the respondent number 2 in partial modification of the earlier departmental office letter number so and so dated 29/10/1991 and office letter number so and so dated 7/3/1992. Following partial modification following issued another letter, office letter number so and so page 43, whereby the decision of the government to make settlement of the government land, government land measuring 3 kathas, 15 shataks, covered by tag number 256 at Moja Ukil Bazar, Pargana Borakpar, was conveyed to the respondent number 3 with a condition that there must be provision for keeping 10 feet for public road to the east of the subject plot and of 16 feet to the west of the subject plot as shown in the trace map enclosed therewith, and subject to realization of the premium at a revised rate. Full stop. The office letter dated 30/10/12/1992 further stipulated that the possession of the subject land should be handed over to the beneficiary after realization of the due premium. Full stop. Para. The matter of settlement rested in such position for a long time thereafter Full stop. Before this court, it is submitted by, it is submitted on behalf of the petitioner. And as stated in the written, in the synopsis of written argument, that Sunil Ranjan De expired on 25/12/2001 and Monjusi De expired on 8/7/2003. Full stop. Para. It has been averred in the writ petition. It has been noticeably averred in the writ petition that the petitioner became the owner of the subject plot located in ward number 25 of the Silsor Municipal, located in ward number 25, Silsor Municipal Board. By way of purchase from Sunil Ranjan De, why they sold it, number 3531, dated 29/8/2005. Full stop. As it has emerged that the sale deed dated 29/8/2005 was executed after the death of Sunil Ranjan De on 25/12/2001. A query was made by this court to the learned counsel for the petitioner about the manner of execution of the sale deed on 29/8/2005. Full stop. It learned counsel for the petitioner has sought to explain the position by submitting that during his lifetime, Sunil Ranjan De executed a power of attorney.
No, after him,
Huh?
after him, his
Ah.
legal heir and his wife. Legal heir means one of his son and daughter and wife. Executed power of
Okay, after his death, the petitioner's husband, Sanjay Kumar De was given a power of attorney by the legal heirs of the original Patadas, Sunil Ranjan De and Monjisi De to execute deed of conveyance in respect of the subject plot. And it was on the strength of such Power of attorney, Sanjay Kumar De executed the sale deed in 2005. You are saying different dates in your writ petition and your written argument.
I've noticed that,
Huh?
but now I have.
Everything is clouded.
Documents.
On the strength of the power of attorney. Such power of attorney. Poster. The legality and validity of such transaction. This court is not this court, for the purpose of this repetition is not going into, is not entering into the legality and validity of such of the manner in which the subject plot got transferred in favor of the petitioner. Full stop. After execution of the sale deed, para. The petitioner made an application before the respondent's Silsor Development Authority for permission for construction of a building and boundary wall, etc. on the subject plot. RCC building and boundary walls, etc. Full stop. It is respondent, no, I mean, development authority, respondent over to continue. The Silchar Development Authority on 19/9/2005 issued permission for construction of a two-storied RCC building and boundary walls on the subject plot by setting the criteria on the basis of the drawings submitted by the petitioner. In pursuant to the permission granted by the Silchar Development Authority, the petitioner undertook the construction works of the RCC building and the boundary walls. Full stop. Para. According to the petitioner, comma, problem arose in the year 2012 when the authorities from the respondent Silchar Municipal Board entered into the boundary of the subject plot forcibly and damaged it substantially by making excavation. Full stop. It was then the petitioner came to know about the modification made in the settlement proposal by the government on 30/12/1992. Full stop. Agreed by, what is the order? 27/2020. Agreed by. Agreed thereby, comma, the petitioner preferred a writ petition, comma, writ petition WPC number 4864/2012. Full stop. After hearing the learned counsel for the parties, comma, the writ petition WPC number 4864/2012 was disposed of by an order dated 27/8/2013, granting liberty to the petitioner to approach the revenue authorities with an appropriate application, agitating her grievance. Full stop. It was observed that in the event such approach being made, comma, the revenue authority would dispose of the matter, taking note of all the attending facts and circumstances, and in accordance with law. And an opportunity of hearing should be provided to the petitioner. Full stop. The order, it was further observed that the petitioner would file the appropriate application within a period of 15 days, and the revenue authority would decide the same as expeditiously as possible. Full stop. After the order, after disposal of the petition on 27/8/2013, comma, the petitioner submitted an application before the revenue authorities, district revenue authorities, Full stop. Prior to disposal of the repetition, comma, and during the pendency of the repetition, comma, it is no, it can be noticed that during the pendency of the repetition, comma, the settlement officer Kachar and Hailakandi, district Kachar and Hailakandi, made a joint verification of the subject plot on 25/8/2005 at the instruction of the respondent number 3. As per the instruction dated 7/8/2015 of the respondent number 3. Full stop. Para, after the application dated 12/11/2014 of the petitioner, comma, the settlement officer Kachar and Hailakandi, by his office letter dated 2/1/2015, reported that during field verification, comma, conducted in presence of the petitioner's husband, comma, and upon perusal of the relevant files, comma, papers, documents, etc., comma, it was found that the area of land measuring 3 kothas, 15 chotaks, was allotted, stroke settled by the government, provide orders, provide orders dated 29/10/1991 and 7/3/1992 with subsequent modification, order dated 30/12/1992 with a clear provision that there should be 10 feet wide approach road towards the east of the subject plot and 16 feet wide road towards the west of the subject plot. Full stop. It was reported that the entire process was done with proper information to Sunil Ranjan De. Full stop. It was further reported that on field verification, comma, it was found that though as per the government orders, there was an approach road, 10 feet wide approach road towards the eastern side of the subject plot. But during construction of the building towards the eastern side, comma, overhead iron rods were kept for extension of the building towards the approach road. Full stop. Para. On receipt of the report dated 2/1/2015, the Deputy Commissioner, the respondent number 3, had reported in his office letter dated 3/5/2016, to the effect that as per the direction of the High Court, as per the direction made in the order dated, as per the direction made in the order passed in WPC number 4864/2012, and subsequently filed contempt petition, contempt case C number 307/2014. A report was called for and received, and the relevant supporting documents were perused. Full stop. It was further mentioned that upon field verification, it was found that আগরখিনি repeat করে দিব, hey, towards eastern side 10 feet, 10 feet. Full stop. The what you have done in the meantime?
My lord, thereafter I asked them for this modification order. It was not provided to me, and then another written
Ah.
petition was filed.
Okay, okay, okay. The petitioner had thereafter preferred another writ petition, WPC number 755/2017, with a prayer to set aside. Oh, no. What is that? With a prayer to set aside the order dated, modification order dated 7/3/1992.
No, not that, my lord. I wanted that.
Why you are attacking 7/3/1992 all the time?
My mistake.
Huh?
Is in her favor.
This
It
is
was
my
our
favor.
favor. What happened in that? Do you have the order?
Yes, my lord. It is
Where is that?
enclosed with this note, my lord.
Huh?
Enclosed with this note, my lord, I submitted today.
Okay, okay, okay.
There,
Because many things you have kept.
my lord, it was a mistake.
And for that reason only, this repetition is pending for 7 years. Because some here, some there. Okay, this is 70/55.
Yes.
Oh, I'll come back. Mr. Dutta.
Yes.
In the writ petition, WBC number 755/2017, a reference was made to the letter dated 2/1/2015 of the settlement officer Kachar and Hailakandi. And the letter dated 3/5/2016 of the respondent number 3, wherein observations were made regarding uh, 10 feet wide approach road towards the eastern side of the subject plot, which was allotted in favor of Sunil Ranjan Dey, and encroachment made to the approach road. Full stop. It was submitted on behalf of the petitioner that the petitioner would desire to file an appeal against the same before the Assam Board of Revenue, and to file such an appeal, a copy of the order dated 30/12/1992 would be necessary. So it was submitted that in the absence of the order dated 30/12/1992, it would be difficult for the petitioner to pursue with filing of the appeal before the Assam Board of Revenue. Full stop. In view of such limited prayer, the writ petition was disposed of by an order dated, what is the date?
Ten to 2017.
Hmm?
10 to 2017.
10/2/2017, with a direction to the respondent authorities to provide a copy of the order dated 30/12/1992 to the petitioner. Full stop. In compliance of the direction made in the order dated 10/2/2017, Supra, the respondent number 3, provide office letter dated 8/3/2017, provided a copy of the order dated 30/12/1992 to the petitioner. Full stop. After receipt of a copy of the order dated 30/12/1992, the petitioner preferred an appeal, case number 31 RA within bracket C stroke 2017, page 44, before the Assam Board of Revenue Full stop. However, from the copy of the order dated 13/10/2017, passed by the Assam Board of Revenue in case number 31 RA within bracket C stroke 2017, it can be noticed that The petitioner preferred the appeal against the office letter number is 44 আছে, dated 8/7/2017. আগৰটোতো নাম্বাৰটো লিখি দিব হা, provided a copy তাতেও একেটা লিখিব। Whereby the petitioner was provided with a copy of the order dated 8/30/12/1992 postal. The Assam Board of Revenue, by order dated 13/10/2017, after hearing the parties, dismissed the appeal with an advice to the appellant therein, that is the petitioner herein, to approach the deputy commissioner with his petition, with a petition. Full stop. Subsequent to the order dated 13/10/2017 of the Assam Board of Revenue, the petitioner stated to have preferred a petition before the response number 3. Against the order dated 30/12/1992, whereby the previous order of settlement dated 29/10/1991 had been modified. Full stop. Para. The petitioner stated that no, like, full stop. In response to the on 27/11/2017, on receipt of the application dated 27/11/2017, the respondent number 3 disposed of the application observing that the respondent number 3 did not have the authority and jurisdiction to cancel the order dated 30/12/1992 as the same was passed by the state government. Full stop. Full stop. Subsequent to the order dated 5/3/2018 of the respondent number 3, the petition has preferred the present writ petition. Full stop. Para. During the in the writ petition, the respondent number 6, that is an affidavit in opposition has been filed by the Commissioner, Silchar Municipal Board, stating inter alia that an office order dated 19/1/2019 was passed by the respondent of 5 for demarcation of the encroached khas land. And pursuant to the order, said order, the officials of the Silchar Municipal Board, along with the land revenue staff of the Revenue
Corporation.
Department,
It's not board corporation.
okay, Municipal Corporation, visited the subject plot and its adjoining places on 24/1/2019. Post of finding encroachment therein, the public road of 10 feet was cleared of encroachment on that day. Post of para. It is in the above backdrop, the challenge, the assail made by the petitioner in this writ petition is to be considered. First of the main relief sought by the petitioner in this writ petition is for a direction to the respondent authorities not to disturb the possession of the petitioner over the subject land and not to encroach over the subject land as per the proposal of order of settlement dated 29/10/1991. Post of para. After consideration, the relief sought by the petitioner in this writ petition in the aforestated manner is to be one which is found untenable. Full stop. Para. The original, it was on (29/10/1991), the state government in a revenue settlement department made the conveyed its approval to the proposal for settlement of 3 kathas 15 shataks covered by DAG number 256, situated at Mauja Ukil Bazar, Pargana Barakpar, with Sunil Ranjan Dey and his wife Monju Sidre after realization of due premium. Full stop. By subsequently on seven three 1992, comma, the state government conveyed its approval to reduce the premium amount to 60% from 100%, made earlier on 29/10/1991, keeping the valuation of the land, keeping the same valuation of the land at rupees 2,20,000 per bigha. Full stop. The it was the state government allowed the LOT, Sunil Ranjan Dey, to deposit the premiums in two equal installments. Full stop. Subsequently on 30/12/1992, sorry, 2012, 1992, 30/12/1992, comma, the state government in a revenue settlement department modified its earlier decision of settlement by specifically settlement made in favor of Sunil Ranjan Dey and Manjushri Dey, by specifically incorporating the condition, specifically important conditions that there the settlements would be made by keeping a public road of 10 feet width towards the east of the subject plot, and a public road of 16 feet width to the west of the subject plot. Full stop. A trace map to that effect was also forwarded with the order dated 30/12/1992. Full stop. From the order dated 30/12/1992, comma, it is evidently clear that the settlement process was not complete till that point of time, and it was made specific that the process would be completed only after realization of due premium for the subject land at 60% of rupees 2,20,000 per bigha. Full stop. Evidence sector. Yes. From the order dated 30/12/1992, comma, it can be noticed that a copy of the order dated 30/12/1992 was duly forwarded to Sunil Ranjan De. Full stop. It was only after 30/12/1992, comma, the settlement of the subject land was complete after deposit of the premium amount for the subject land fixed against the subject land. Full stop. Para. The original settlement holders, comma, Sunil Ranjan De and Manjushri De survived till (25/12/2001) and 8/7/2003 respectively. Full stop. The petitioner has not made any whisper to the effect that the said two original settlement holders, namely Sunil Ranjan De and Manjushri De, had made any protest during their lifetime against the order dated 30/12/1992. Full stop. The petitioner herein had stepped into the shoes of the original shareholders in respect of the subject land only in the year 2005. By virtue of a sale deed purportedly registered in the year 2005 in a manner stated above. Full stop. When the original settlement holders despite having knowledge of the order dated, original settlement holders, Sunil Ranjan De and Manjushri De, despite having due knowledge of the order dated 30/12/1992, did not raise any protest against the order dated 30/12/1992 during their lifetime. That is, the lifetime, which lasted for about 12 years after the order dated 30/12/1992, comma, it does not lie. It is not open for the petitioner. Who only entered in the capacity of the landholder in respect of the subject plot in the year 2005 to raise such objection against the order dated 30/12/1992. Full stop. Therefore, in such view of the matter, comma, no assail, no challenge to the order dated 30/12/1992 is found to be sustainable in law. Full stop. Consequently, comma, the repetition is found to be spirit of any merits, and the same is liable to be dismissed. Full stop. It is accordingly ordered. Full stop. Para, as a corollary, comma, it is observed that since there has been provision for a 10 feet wide approach road towards the eastern side of the subject plot, as per the order dated 30/12/1992, comma, the said public road of 10 feet width has to be free of any encroachments. Full stop. If the statement, if the findings recorded if the position recorded in the order dated 2/1/2015 of the settlement officer Kachar and Hailakandi, and the order dated 3/5/2016 of the respondent number 3, as regards existence of iron rods from the petitioner's RCC building over the public road are found in existence, then such obstruction stroke and encroachment are to be immediately removed. Full stop. The petitioner is therefore granted an opportunity to remove such obstruction over the public road, obstruction created by the iron roads extended from the RCC building of the petitioner over the public road within a period of 1 month from today. Full stop. In the event a petition does not remove such obstruction on her own within such period, comma, the responding authorities, comma, more particularly, comma, the authorities in the Silchar Municipal Corporation shall remove such obstructions within a period of 1 month thereafter. Full stop. It is further observed that in the event the petitioner or anyone resist such removal exercise, then the respondent authorities are at liberty to take assistance of police, to avoid untoward incident and shall use are permitted to use necessary force to remove such obstruction.
With the status quo order passed earlier, that may be vacated.
The order of status quo passed earlier
Dated
stands recalled.
23/7.
Stands recalled. Passed on 23/7/2018. Stands recalled.
Much obliged.
So I am granting you one opportunity. Otherwise, if they go, they may damage the building. So you remove it on your own. Or you file an appeal.
Obviously, we could not do anything because of the status quo order. Much obliged.
Oh, yeah, 1 minute before that. Yes, Mr. Borua. 1 minute. Just for some information only, this was. Yes,
That matter, my
on that matter. I fixed it today only for a will you please take your seat. I fixed it today only for a limited purpose.
Yes, ma'am.
Regarding that order of the Honorable Supreme Court
Yes, ma'am.
of
The diluted as paragraph.
whether it has been diluted somewhere subsequently.
Yesterday, when I checked it up, subject to a correction, it has not been diluted.
Huh?
But it-
I have not gone through.
yesterday I checked it up, but after this order, there is a fourth decision in 2024. That case, this husband, this paragraph has not been diluted, even 2025 also.
Let us ask Mr. Gogoi.
I couldn't find, but I just received an instruction from the DFO, Your Lordship, that says the proposals which they have annexed here, that was scrapped away, Your Lordship. There's no proposal before this authority.
No proposal.
So there's no proposal. A 10-kilometer radius stands. If we go by this Goravam judgment, if it has not been modified, and the brick lane is between 1200 meters. It's, if we count kilometers, 1.2 kilometer.
1200 meter. Otherwise, 10
10 kilometer stands.
So ultimately, it is Mr. Bora who has to respond.
Yes, sir. If I may place
Good
this instruction for your perusal, Lordship.
Very good. No, I'm not sure.
Can you make this statement in the form of an affidavit? One page affidavit.
One page, I can, Lordship.
That there is no proposal regarding eco-sensitive zone of Pobitora. Then that will come into force. That 10
kilometer
kilometer.
radius.
Right. Let us have it on record.
Very well, Lordship. I can put it on record in a day or two.
Then the ball will be in the court of Mr. Bora. Where is Mr. Bora? 10. So will he be available today?
Yes, Lordship.
We'll ask him whether he has found anything which has diluted that order. Then we can proceed thereafter. But in same this thing, what is this decision running Godavarman?
Yes, Godavarman.
Some Supreme Court has scolded
Easier.
Allahabad High Court also recently. Why you are meddling into our affairs?
It's been going on.
Huh? Yes, Mr. Bora.
I have judgment. There are other judgment also as mentioned in the two judgment, but it is difficult, orders are difficult to find. Therefore, I require another some time. Because at para 23 of the letter judgment, in one paragraph, it says that Goa Foundation case of 4/6/2024 does not restrict orbit for 10 kilometers. Then again, 56.8 says that maintained as per 46,006. Therefore, there is some confusion. There are other orders in between.
But it is now made clear by the forest department that there is no proposal pending regarding eco-sensitive zone of Povitra Wildlife Sanctuary. They will bring it on by way of an affidavit
Affidavit.
on record.
Yes.
So all other conditions are fulfilled for 56.8
Yes.
other than your submission whether this has been diluted.
Diluted or not.
Because the judgment of the coordinate bands has not referred to that part.
Yes.
That order itself is not mentioned in that.
But the order of 2023.
That is a different
refers to
context.
earlier order.
That is a different context. That order of the Supreme Court is not referred to. If it is not referred to, wherein direction are there, which can be read under Article 141, right? And it will be a binding precedent.
Yes.
Then non-reference will be per incuriam.
And it is,
That is why I have said, because your Bricklin is involved in the process,
yes,
right?
yes, sir.
So this is what, unless you show us specific dilution of 56.8,
Yes.
then
Something can be.
nothing can be done, right?
Yes.
Prima facie, I am saying,
So one-
subject to your submission, we are not dealing with any matter today. I have asked them to bring it on affidavit
Yes.
that there is no proposal. Then all the conditions of 56.8 would be found fulfilled. Then it is for you to register.
Yes.
Not on the strength of the judgment of the coordinate bench,
Okay.
but dilution of 56.8 by the Supreme Court itself.
Yes.
Yes, Mr.
Yes, sir.
Let us have it on record, otherwise it will be difficult.
There is a court decision in 2024,
Hmm?
court decision after that order, Godavaran case, my lord, there are two other court decision, but those decision, there is no dilution, that is paragraph 56.8.
That is why it is for you, Mr. Gogoi, both of you are saying that there is no dilution. Since his Bricklin is at stake, right? So let him have an opportunity, because Godavaram is coming up month after month.
Yes.
R. Borua, R. Gogoi, who is for a state, M. Bormon, B. Chaudhuri, a P লিখিছে দেই, B লিখিব। PCBA is available. Take it. S. Borua, PCBA. And BP Bora, 12. So stop. Mr. Gogoi, Learned Standing Council Forest Department, Environment Forest Department has submitted that as per latest instruction received by him, at present, there is no proposal pending regarding eco-sensitive zone of Povitra Wildlife Sanctuary. Full stop. He has submitted that he would like to bring the said fact on the basis of an affidavit. Full stop. The such affidavit is to be filed within 1 week's time. Full stop. Mr. Bora, Learned Council appearing for the respondent number 12, has also sought for a week's time to complete his instructions. Full stop. Okay. Place the case. First of December.
Obliged, Lordship.
Part heard, my lord.
Not part that. That day I'll be available. I don't know. I'll have the roster or not. A week prior to that, I'll not be available. So I did not fix it. Yes, Mr. Hazarika.
Yes, my lord.
Lordship
We
has
have a
heard
partner
the-
matter, we'll take up at 3.
Lordship has heard the matter at length, my lord.
I forgot,
Yes,
I
my
don't have such
Lordship has
a
also
huge
recorded,
memory.
Lordship has also recorded
Yes.
the submission of both the parties, my lord.
Forgot, but if you have placed
Yes, ma'am,
about
I have-
20 decisions, both the sides.
I have summarized my submission. You may take it.
Oh, Miss Dotto's matter, we'll take up now.
I have summarized my submission in. That is already in record.
For the respondent side, Miss Kolita,
Swami appears, Additional Advocate General.
Yes.
So he just asked me to seek accommodation just for the day. There was some difficulty a lot.
okay, you keep so that I can make it. Okay, it is there perhaps.
Yes, my lord.
Oh,
At time two cases were there.
okay, okay. Nobin Gupta is no more
No more,
pursuing the petition.
my lord. My lord, by,
I keep it, I am returning it.
yes, ma'am.
When Mr. Goswami is available,
Any day, your lordship, except today.
any day. Next week to 18 বা 20 কি আছে?
Lordship,
20,
20.
20.
For further
Next,
hearing.
next.
My lord,
next.
yes, ma'am. Item 4.
P. Hazarika, Learning Council for petition is present. On the request of Ms. M. Kolita, Learning Council for the official respondents, lays the case on 18 or 11. Interim order pastorate shall continue till the next. That day will close.
My lord.
Lordship, just a small request. The name of Mr. P. N. Goswami shall be
The name of
reflected.
Mr. P. N. Goswami, Learned Traditional Advocate General, is to be reflected in the respondent side in the cause list. It will,
Obliged.
Obliged.
Yes, anything urgent before I take up 9?
All right. 6 and 7. But one IA file for the respondents. My lord, that IA, my lord, the reason is this: the writ petition has been filed by the persons. Previously, there were 2 writ petition. Their prayer was for demarcation, and as demarcation notice was sent to me. And thereafter, both the writ petition were clubbed together and disposed of, and it was sent to the circle officer for some report. The circle officer gave a report that in a particular dag, they are not in a position I am holding and I have a title and everything. Against that circle officer's report, they came before this court in a writ petition. On the first day, your lordship declined to give any interim order. And thereafter, my lord, now one of the private respondent has expired. His name has been substituted. His father expired and his name, the son's name has been substituted. I have filed an application for mutation over there. That because my father is expired, give my name as in the mutation. Well, because of the writ petition, they are not giving me the mutation. That is why I have prayed for a mutation. They have filed an objection. They don't know what is their case, my lord. Their writ petition is not maintainable. They don't want my mutation to be done.
Looks like it will be contesting one.
Lord, your lordship may just look into the order. Your lordship will find the writ petition is not maintainable against the circle officer's order. That is why on the very first day, your lordship declined to give any interim stay order.
Which one is there?
6 and 7, my lord.
7 and 8, my lord. What happened?
7 and 8.
One respondent, right before filing the writ petition, my learned senior friend has not supplied this information. Only few months back, substitution is done. So that is why when he is said that the respondent is died, that is why the interim was not filed. But what happened?
No, but the first day.
We challenge this order because there is a direction of this honorable court to demarcate this particular plot of land. They opposite. Interim order vacated, their petition disposed. Then demarcation was not done to particular land. That is why agreed.
Circle officers
we have
report.
filed this writ petition, my lord. That is a before pending.
My lord, when it came, my lord, your lordship may just look into the matter. A circus officer report, how could a writ petition is maintainable, my lord? There is a appeal under
It is
147.
direction of this honorable court circle officer to finish this demarcation, come to a logical end. That was not done. His
Okay, we'll put
arbitrary-
it on next Thursday.
Yes.
On next Tuesday, my lord. Dispose of the whole matter, your lordship will. Tuesday, my lord.
Tuesday.
Tuesday.
18.
As on the request of Mr. P.K. Raichuri, Learned Council, for the petition.
I am private respondent.
Mr. M.J. Burwa, Learned Council for the petitioners, and Mr. P.K. Raichuri, Learned Council for the private respondents. List the cases on Tuesday.
1811.
Obligement.
Obliged.
May it please, your lordship. I beg to mention item 5, Lord.
Yes?
Matter will be fixed on 20th.
No, already next week done.
Next Thursday.
Next Thursday done.
Then second week of December. Actually, Learned AG is appearing. He was not,
Second week of December.
yes.
When? 9
On any hearing day on second week of
9th of December? Okay, Mr. You are for respondent?
Yes, my lord.
Okay. And Mr.
A. Hussain, lordship.
A. Hussain, Learned Council for the petitioner, and Mr. V.D. Chudhary, Learned Council for the respondent. Have made a prayer to fix the case on another date as agreed to. Release the case on 9th
9th.
December. Tuesday.
Yes, my lord.
No, please, the lord. So item number 6, lord, matter relates realizing the land acquisition compensation. So considering the urgency earlier to time was granted.
No urgency in comparison to the matter I am going to take up
No,
of
lord,
2013.
I am, may I plead your before to fix the matter after 1 week, lord, so date may be fixed. File their addition, affidavit in opposition.
2025.
Earlier to the.
I don't know why. Okay, wait a second.
Last order was 20.
Counter affidavit is filed or not?
No, lord, so no affidavit has been filed by the SWD department.
You wait, then after that we'll take up. After this matter, we'll take up.
May I please? I would like to mention item number 21 of supplementary list.
Why you are mentioning in the morning?
My lord, in this
Okay,
case,
you
step
are
has
not-
already been taken. Step has already been taken, my notice of issue and
21.
step has already been taken, my lord. But, my lord, this matter perhaps come in the hearing, admission or hearing matter, my lord.
Mr.
G. Ali, my lord.
Jiali Learned Council for the petition is present. As per office note dated 12/11/2025, the service notice has been duly served. Upon the response number 4. Post up. As all the respondents are duly served with their notices, office to release the case after 1 week in the admission program.
I'll kindly fix a date, my lord.
Nope, wait.
I'm obliged.
So item number 20, your lord.
Ah.
Also matter pertaining to phasing of bank account, your lord.
Similar situated matter only considered by the coordinate bench group. In respect of by supplying the order unit.
No, I am not going to hear you.
Lordship,
fix it.
Bank also there.
Please
If
the
they
case
have not,
on next Friday.
Lordship. So,
Sai Akond, petitioner, and Mr. M. Sharma
yes, your lordship.
for the respondent bank.
Yes,
Sir President. And Ms. M. Borman, Leonard, with Assam for the state respondent.
21st November. Part heard matter for hearing. Item number 9.
Mr. Ahmed. You said public premises unauthorized occupancy act 1971. Right?
Yes.
Because by virtue of Coal Mines Nationalization Act, certain lands have been vested in you.
The entire land.
Entire land. But when this particular entry is appearing in the records of right, Jamamandi,
Yes.
staying at your face, that annexed, I think, as somewhere in the repetition. That by virtue of position,
Yes.
it is Devnath. Name is mutated. Right?
Yes.
So, rightly or wrongly, he has a bona fide claim for occupation. Possession of land. Right? So, if his entry, mutation entry is wrong, he should have taken effort to remove it.
He, in fact, was removed.
Huh?
In fact, he was removed. He
No.
again came back.
No, that is demolition.
Hmm.
Demolition and eviction is different.
Yes.
You went there, or whoever, XYZ. Let us assume XYZ. They went there, demolished the coke manufacturing unit.
Yeah.
Right.
There's no eviction that day.
No eviction that day. For the purpose of eviction, the Procedure of Public Premises Act are to be followed. If if you were vested with this land,
Yes.
right? And the procedure is that you have to put the man on notice. Allegedly unauthorized occupant. Right? And it is not that only he has to lead evidence.
True.
While claiming ownership, you have to also establish.
Both parties.
Right? The title. You can establish the title if it has to be laid before the estate officer. Both the parties have to lead evidence. Thereafter, order under section 5 can be passed. Nothing has been done here.
True.
That is not there.
That in that view, the matter, in fact, this case has no merit at this stage. It's liable to
1
be.
minute, that is why because this case is pending for 12 years, that is why I was thinking why it is pending for 12 years. That is one. So you have to follow the procedure.
That will do.
So far as demolition is concerned, third prayer, your FIR was registered,
Yes, it was registered.
investigated, search-sheeted, accused faced the trial, got acquitted. After finding by criminal court, the third prayer is redundant. Along with the third prayer, those who have been acquitted, your specific allegation was that in the demolition process, these persons were involved. Now they got acquitted. There was no appeal. How can I read court? Put the blame on them. Have you understood?
Yes.
Your third prayer is that
investigate on the basis of first information report dated 26/7/2013, page 19.
You're referring to the prayer portion?
Your
or-
prayer portion. Three prayers. Three prayers. One is declaration of unauthorized demolition as bad. Right?
Yes.
Pay compensation of rupees 2 crore. Third is
Register the case.
that has attained finality.
That is because
Accused to
the
the
actions
trial.
of time.
Accused who were officials of Coal India. They faced the trial, got acquitted, benefit of doubt, whatever. After that, we don't know because exchange of, yes, there was a demolition. Admittedly.
Yes.
State put the blame on Coal India officials. Coal India officials put the blame on district administration officials in their
I
affidavits.
think apparently.
No, I have seen.
correction.
No, their affidavit said we provided
Your
the
Lordship peruses
machinery.
Peruses
As on that, we cannot do after acquittal.
so even the district administration also, their prayer was for demolition. So they accordingly.
No, I
provided the
say
adequate
demolition
staff.
is
Exactly.
wrong.
That is true. That is what I am.
But for fixing liability. Second prayer. Because of the judgment of the trial court, matter was investigated, 4 or 5 persons were searched, who were all Coal
Get
India
it to your
officers.
Lordship, but the thing is.
After that, we cannot,
No,
after
there is-
acquittal.
No, that was the initial stage of the proceeding. When we finally, that was the prayer made. But I think this writ code will not go into the merit of that FIR part and the subsequent criminal trial that was held.
Why not?
Because my,
Subsequent developments are to be taken note of. Why not?
that is true, but what I'm on is something else, your Lordship. Because it is nobody's case that there was no demolition. There was demolition. And that demolition is also from the record, it comes materials before available
You
before the
file
record.
it because we are not fixing any liability.
But then demolition is admittedly done.
Demolition is done, but who had done it?
Demolition was done by them because they had requisition, because if your lordships go by the documents that has been placed on record, that they had approached the district administration to provide the adequate security and the other forces that was
Approach.
required.
That
They had done. It is nobody's case that there was no demolition.
I am not saying that.
No,
there
that is
was-
what your
No.
lordship is saying.
Fixing liability is difficult now.
But then this writ code may not they will not be able to go into the trial because who has demolished? Because admittedly from the records available before your lordship will have to agree, will have to go into consider this particular aspect of the matter. The demolition was done because they had gone for the requisition of the adequate number of forces to avoid any security law and order problem, and that was admittedly done. And they are also not denying it from their affidavit. Your lordship will come to their affidavit, what they had approached the district administration for. Your lordship will kindly come to the affidavits that have been filed by the district administration. Your lordship will kindly come to annexure 1 of the written statement filed by the respondent number 2. The respondent number 2 is the Deputy Commissioner Tinsukia. In their affidavit, if your lordships comes to the affidavit that was filed by them, there it is on the letterhead of the Coal India Northeast Coalfields. Request to provide sufficient security personnel along with magistrate for demolishing 2 numbers of coke bhatta in the leasehold area of Tilap Colliery Northeast Coalfields. It is addressed to the Deputy Commissioner Tinsukia District
under the letterhead of Northeast Coalfields, the general manager so and so. He writes to the authority, we sincerely request you to kindly instruct the concerned officials to provide the security personnel along with magistrate for apprehending law and order problem during the course of operation. And thereafter, what's the district administration writes to the Northeast, the Northeast Coalfields, the general manager. Your lordship will find it in the next page. Subject. Next page, your lordship, page 6. Annexure Roman 2. Derailment of executive magistrate for maintain of law and order duty on 26/7/2013. With reference to the subject cited above, I have the honor to inform that Sri Bipul Das, ACS, EO, Executive Magistrate Margherita Subdivision is hereby detailed for maintain law and order duty during the time of operation for demolition 2 numbers of bhatta owned by our petitioner, it is Devnath and so and so.
These are anterior to the incident.
Exactly. So that process was initiated by them. So it is their document and the administration's document. It's not our document. So that part your lordship will have to agree. It is another thing that in the criminal case, they have been
Agree or
absolved
not
of
to
liability.
disagree, it is the discretion of the court.
Pardon your lordship.
Agree or not to agree.
Yes, definitely. But this
So
is their
these
documents.
are
It is not my
prior to
document that I placed it with my lordship.
26/7/2013. So after, did you take part in a trial? Did you take part in a criminal trial?
I think we have taken part in the criminal, subject to correction, because that instruction I may not have. But then that is besides your lordship. Acquittal of the criminal proceeding is a different
you are-
matter. But admittedly, your lordship in a writ court will have to appreciate these documents. It is not my document that I have relied it. It is the document that has been filed by the respondent Coal India authorities before
How
the district
many
administration.
persons from the Coal India Limited were seated?
That, of course, your lordship may not be before in this writ proceeding before me. So at that part, so far.
You have
that part-
provided the judgment, copy of the judgment. We have taken note. We can, subsequent events definitely
No,
can
I
be taken
didn't
note.
provide the judgment.
No, no.
I think they provided it.
Okay, they provided.
People.
How many?
No, criminal proceeding, your lordship, is on a different premises. What I am saying is that I am answering to your lordship's specific query. Your lordship's specific query is that whether the demolition had at all taken place.
No, I have
Just
said-
because there is an acquittal, that by because there may be acquittal for very many.
No, we do not go for roving inquiry, Mr.
No,
Chaudhary.
lordship.
We do not go for roving inquiry.
No, I am not asking your lordship to
No
go for the
roving
roving
inquiry.
inquiry. But admittedly, your lordship will have to agree the annexures 1 and 2 of the document.
That is why I said it is pre-incident.
Oh, definitely.
Pre-incident document.
Pre-incident document. So thereafter demolition had taken place.
Okay.
And my another
All
prayer,
your
with your
judgments have been
lordship,
taken note of.
another prayer, I make a small submission. On the earlier occasion, I placed 3 decisions.
All 5, 6, 7 I have recorded. All. Shall I
And
repeat?
so far as this public.
Shall I repeat?
No, your lordship may not repeat. I am on just that has been referred to.
This 1 minute, so that I do not miss. One is Whirlpool.
Yes, your lordship.
One is Midnapur. One is Bishan Das. One is State of West Bengal versus Vishnu Narayan. Right. Then four. Any more?
No, your lordship. I have relied on 4 judgments.
Then they have relied on Bharat Coking Coal regarding testing of the coal mines. The Northeastern Coalfields Coal Limited versus Mubarak Ali, same, on the same point. Then H. Laxmaya Reddy regarding mutation. Coal Mines Nationalization Act. It is also a fact that you have come back, so you are still running.
Yes. On the previous occasion, when there's an effective hearing, maybe about, I exactly do not recollect the date. I had placed a copy of the Jamabandi. There I have said the land owned by Coal India Limited. That may be made part of the record. I had served a copy to them as well. Total area of land occupied by them, owned by them.
No, this is difficult, but the only thing is that your name has been recorded
Yes, your lord.
by way of mutation. দুই বিঘা এক কঠা।
2 বিঘা 1 কঠা।
ভোগ দখলি। Nothing by way of title deed.
Definitely, not by way of.
Not by way of title deed, by way of, I don't know.
No, whatever it is there,
Whatever
I am
manner,
not going
somehow
to make a different.
your name
argument.
is mutated. So no title.
One
So far-
submission may be recorded. I am not putting it from pleadings. As per my client's instructions, the instructions that I received previously, not at the time.
For the court, one part is difficult because of your name recorded in the Jamabandi. We don't know whether this, because they are not claiming removal or deletion of your name from the Jamabandi, stating that this land is ours, right? So his name is to be removed. Then the doubt arises whether this is Coal India land or government khas land.
In fact, I do not know what instructions the government has.
I don't know.
That is not, I'm just making it just a
Or
submission.
for a read code, it is
No,
difficult.
definitely. I have
Because
been
they
told.
are sitting over it,
Exactly, no, what I have
knowing
been told.
fully well that his name has been incorporated in the revenue records. If that is 2 kathas or 2 bigha is part of your land, then nothing has been made. No steps were taken for his removal, name removal.
There are hundreds of similar
So
problems.
it is for a read code, these are the difficult.
I am not pressuring the read code to make a
These are
call
we
on
are
that.
proceeding
So,
separately. It's not.
If it is Coal India land, it is the public premises 1971 Act, the procedure is to be followed.
That we
Right.
accept.
If it is government land, then the settlement rules framed under the Assam Land and Revenue Regulation are to be
That will
followed.
come.
That can be followed by circle officer. This is an act which neither falls there nor falls here. And because of a doubt whether this plot of land,
There is no doubt on that. We've given ultimately we give the copy of the patta also. That this is our land.
that is what, why don't you remove his name?
That process is separate.
He has a right to be heard.
That's true. No, that process will continue.
There is no prior opportunity of hearing.
In fact, that is the first stand in our read petition. Even
Right.
assuming
As you
their
were
process
pointing
of
out,
demolition
this is
was
the case of-
rightly done.
Two rights. One, right to opportunity of hearing.
Hearing.
After first right, second right is to be determined. That is right to possess or not to possess. Right. Second right cannot be determined without following the first right, without compliance of first right. Here, apparently, prior opportunity of being heard was not provided to the petitioner.
In the matter of eviction. which we have not done.
The law that has been developed At least he has a right because of his name in the revenue record.
That is true.
That was not done.
And that process will continuing now. In between, we didn't have a state officer.
So this process is gone.
Then this process.
Whatever you have to do, everything has to be done afresh. Looks like.
This is.
You were running the show there from that plot of land.
So far, there's no.
We do not know this is a Patta land, Khas land, Coal India land. We don't know. No procedure by the circle officer or district administration, revenue authorities, not by the Coal India. So act of demolition was a fait accompli. It was done. But again, you re-established. Trial conducted, completed. Nobody was found guilty. So you run the show, they go their own merry ways. After removal only.
In this connection, may I just make a small submission, Your Lordship? I am told, as per my client's instruction, that it was earlier under ARNT, Assam Railway Trading Company. Then after nationalization of the coal fields, it got merged with them. Now, this earlier lease during the period of British Raj, it was for 99 years. Somewhere around 2003 or 4, that lease of 99 years period had elapsed. Thereafter, they have never gone for further renewal of the lease or for.
Let me correct.
That is the instruction that I have.
That is
received.
extended.
up to 39.
Lease has been extended.
Up to 39.
So we will not go into that aspect then. If it is
Exactly.
there, Mr.
No, since it has been, since it has cropped up, that is why.
Since Mr.
Supplementary
is saying,
submission.
so we'll not go into that aspect. We confine ourselves to this, but some doubts still remain because your name exists in the Jamabandi, meaning thereby you had a possession. So at least you had the opportunity, you should have the opportunity of being heard, whether by it is district administration or by Coal India Limited. If it is district administration, it is by Assam Land and Revenue Regulation. If it is by Coal India, Public Premises Act. But question is that you have not made any effort to clear his name.
Not yet.
From the Jamabandi.
No, not yet.
Not yet. So you can have the opportunity now to remove his name.
Till now.
Then thereafter, or Public Premises Act, you follow whatever, it is up to you. Demolition is a fait accompli now. But fixing liability is difficult for quantification.
No, though that was a prayer, I agree. For
I
a
said
court
difficult,
regarding
not
compensation.
impossible. I said difficult, not impossible. Anything?
No.
We have given 2 judgments on disputed questions of fact.
Which one?
Earlier occasion we had given.
Which one? Which one? I have the all.
State of Jammu and Kashmir. Photo record.
It's on record. One is regarding state of Jammu and Kashmir versus Ghulam Muhammad Dar.
That is not there. Mr. Doctor, you have any copy?
Will he'll hand over 2 copies. Did what? It is इसलिए ना
Oh, एक है. 6 and 7. Wait a minute.
এই 2 খন্ডে Worship, there's another exactly similar case. The next door neighbor of my friend. That also, that was dismissed.
That
Now-
Ganesh. Ganesh. I have an instruction in that regard. I earlier also,
There is an appeal
my learned
pending.
senior had raised this point. My instruction is that this land where this Ganesh was set up, that land was under occupation of a Coal India employee. He, after a flux of time, he had handed over it to Mr. Ganesh to run that unit. After retirement, he never ensured that the land comes back to the employer so that he can hand over it to the employer, that is Coal India Fields. Thereafter, this initial process was initiated, and accordingly, this Ganesh had no other option but to quit that land in due process of law, whatever reasons be. Because that land was handed over to Mr. Ganesh by an employer of who under whose occupation this premises was there. Maybe he was occupying that plot of land by way of a quarter or for whatever reasons. So ultimately, after retirement of the gentleman, Ganesh had no option but to, after though he had come to the writ court, ultimately after this proceeding, that
Writ petition was dismissed.
Yes.
Writ petition dismissed, then civil suit he filed. That has been.
Definitely.
It is pending in the High Court now. RSA.
RSA.
Definitely that will happen. Because assuming your lordship, suppose occupying some high court land in a form of a quarter, even if I am given a small space of 10 by 10 feet, after your lordship's retirement or maybe elevation of whatever reasons, that portion of the land, the authorities will definitely claim. That is on a different premises. Because that was my specific query, that how can Ganesh be dismissed and your case survive? He said that no, this is the instruction that I had. That is my submission.
Okay, I'll try to complete it today, and otherwise we'll reserve.
So lordship is reserving it, or?
I'll try to complete if the time permits, sitting in the chamber, otherwise I'll reserve. If it is not possible to complete, I'll reserve.
I have no problem at all. Only thing that matter should come to a logical, because tomorrow there may be some other adjacent plot of land people coming into the court. So those, so that district administration also makes an effort. Those things should be also maybe put on
Already
record.
hundreds of cases pending in the court of the state officer under the Public Premises Act.
No, yes, that should have been a proper approach thereafter.
I could pending person.
Both the sides should lead evidence, because initially the impression was that you serve a notice upon the noticee, and he will lead evidence that I have a right to possess this land.
That
No,
procedure-
Thereafter, Supreme Court said, no, it is not only his responsibility, it's the responsibility of the claimant owner also to establish that it is really his plot of land. Right, for that they have to also lead evidence.
Lordship, the Supreme Court case which is there before your lordship. No, not Mubarak Ali, the other one. They, after the nationalization, the owner of that particular coal mine, as director, he had his bungalow within the premises of the coal fields. Ultimately, Supreme Court held that also goes to Coal India. If it was used for coal mining activities, it belongs to Coal India. Belongs to Government of India, which ultimately gave it to Coal
But-
Mines Authority.
In the Jamabandi, you have permissively allowed him.
That without knowledge to us, no notice, nothing. So no notice at all.
No, in 2013 also, when he enclosed this as a part of the writ petition, you had the knowledge now then that this man has recorded his name in our lands.
No, we've been aware of that, but because of the pending case, we have not.
There was no stay.
No stay here.
You could have said that, yes, we have initiated the process.
And that we can still carry on because we are still initiating proceedings. Many.
No, at that time,
What has happened? These are
when
past
I
things.
drafted this writ petition, when I was attached to my senior A.K. Bhattacharya, the situation as I could perceive now was that after demolition, there was complete silence from them. They also knew that there was something wrong.
No.
So they did not, after filing of the
No.
writ, it was also not put in this case, in the pleadings, that why they have not initiated that, or they had initiated the process. Having come to know that it is not in our patta land, they decided to demolish. No, it is not their stand. If you go through the pleadings of the district administration and the coalfield, Northeast coalfields, the respondent authorities, it is nowhere there. on that
Because
fact.
they are not saying anything. District administration.
They are silent.
They are also
The
keeping
mischief-
mum.
mischief
Mr.
is
Hendig
done.
is,
I am told
Mr.
recently also
Hendig is
that most of the people,
maintaining silence. All are hands in gloves.
That is the problem.
Problem lies there only, which we cannot say. See the,
In fact, it's a very
see,
serious
see
problem.
their statements. Somebody says, I have seen. They did not say anything regarding title. The petitioner's name found recorded at serial number so and so, along with Patadar, on a plot of land measuring 2 biga 1 katha, on the basis of being in possession by circle officers, order dated 21/6/2004. If you are the Patadar, you should have initiated. There is also inaction.
Inaction is, they're still trying to ascertain which are the areas. Every day there are encroachments. It's a vast area.
I have a humble prayer before your lordship. While disposing of this matter, your lordship will make some observation that since other stakeholders are there, including the Coal India authorities and other who are similarly situated like the petitioner, so a pragmatic approach should be made by in collaboration with the district admin to identify who owns the land, and a proper approach should be taken. So that tomorrow again somebody comes before a court in respect of the same area within this area. So that pragmatic approach will be better in that course.
Fine.
That is my humble submission.
Okay. Rose.
Much obliged.
We'll try, otherwise reserve.
We don't have any issue, your lordship. Since we have waited for such a long time, it may not make any much difference if we wait for a little longer also. Obliged.
Oh. কি প্রেয়ার করেছিল? কি প্রেয়ার করেছিল তো? বললো ইয়াতে এফিডেভিট দিবই আছে, হিয়ারিং কৰিব লাগে। কিবা কৈ থাকে, হিয়ারিং কৰিব লাগে। No, some standing council PWD is supposed to file. Standing council PWD for the respondent number 225 is found absent on call, full stop. No affidavit in opposition, counter affidavit on behalf of the said respondents, in deference to the previous order dated 29/10/2015, has been filed till date. Post up. Later case will state after 2 weeks on a date. Huh? No, it was cyberless escrow again. Yes, anybody? How to do it? Paro. No, no. Rest of the matters I'm not taking.